Hello there, and welcome once more to another Open Door show from Property CEO. My name's Richie Clapson. Of course, you always know that because it says it on the screen, and it's great to have you here with us. And over the next 30 minutes, as always, we're going to be taking a deep dive into the world of small-scale property development. We're going to be talking some of the movers and shakers, and I've got someone very interesting to talk to you today. Actually, very interesting for lots of reasons, but one particularly in terms of the name. We'll come to that in just a minute. And those people are going to give us a bit of an inside track on what's actually happening out there in the property world. Also, often be shining a light on any areas that we think are a good opportunity. But as always, and most importantly, can have a bit of fun doing it. So who's on today's show? Who's on there for your delight? Well, we have someone today from a company called Woodstock Legal Services, who I've worked with in the past. And we have managed to get here today the director and head of property and litigation. So we have on here a real treat for you. This lady has worked at a number of global city firms and specializes in all aspects of commercial property disputes, not somewhere where you want to be. So maybe actually we can find out how we don't get into a dispute. So welcome to today's show, Simone Ritchie. Simone, how are you?
Good morning. I'm great. Thanks for having me today.
Pleasure. And as I said to you, look, we've got the same name. We've just got it in a different order. Simone Ritchie, so with the same spelling with a T in it as well. Where does the name come from?
Scotland, as you can tell by the accent. I'm on the East Coast. I think you might be West Coast. But yes, no, it's Scottish. Think of Guy Ritchie, not Lionel Ritchie.
Good stuff. Well, I'm not Scottish, and mine never came from Lionel or Guy at all. So my name came from my parents, so they were very pleased to give it. I tell you, as a little Simon, just as an aside, someone once years ago, when I was about 19 or 20, I was working in a drawing office, and they said, "Oh, you're Richard, aren't you?" And I said, "No, Richie." And they said, "Well, you can't. You must have been christened as Richard." And they had a bet with me, and I took the bet. Why not? I won 20 quid. I bought my birth certificate and they went, "Oh, really? Never heard of the name Ritchie." People have often heard of it as a surname, but not as a first name. There we go.
Well, I normally get, can I speak to Simon? And I'm like, "No, it's Simone." And they're like, "I don't think so. It must be a man because you're a lawyer. So can I speak to Simon Ritchie, please?" And I'm like, "No." And when it's always useful in litigation when somebody phones me and says that, because they're immediately on the back foot, and then I can take advantage. So,
isn't it? But the trouble is, I'm afraid to say, I've got a lady that I've worked with, a structural engineer. Okay, Charlotte, her name is Charlotte Blake, and she always signs off as Charlie. Okay, but she said when she turns up, people go, "Oh, you're a woman."
Mm-hmm.
Yes, and the problem is, I mean, she's a fantastic engineer, but she said, "I just get fed up with it.
Mm-hmm.
Terrible world.
Always.
So Simon, oh, sorry, Simone.
Once, you could do it once.
I'm allowed once. Good job it's virtual, otherwise we'll be starting a fight with the Scots, won't we? Simone, so look, you're there at Woodstock Legal Services. I've worked with Woodstock, some of your colleagues there, head of property and litigation. Interesting world out there. As you know, we work with developers, small-scale developers, training them going forward. I want to just really pick out today what we think is, the good and the bad and the problems that people make, and maybe start right at the beginning when we buy sites as developers. What are the biggest issues or the biggest mistakes that we make wrong when we're going to go and look at a site, an existing building or a site, and we think we can do what we can, but suddenly the whole thing implodes? What's the biggest issues that we start with?
Well, the biggest key thing that everybody should know is the saying of, prior preparation prevents poor performance. And by that, I mean getting your right team in place so that you've got the right people giving you the right advice and giving you the right steer and direction that you want to be going in. With that, the other big thing is don't mistake having the benefit of planning as allowing you to do what you actually want to a site and having carte blanche to do it. By that, I mean, anybody can apply for planning on any bit of land or any property, and they can obtain that planning if, the planning authorities allow it. Just because you've got planning doesn't mean you can actually do what you're wanting to do. what you have to do and what you have to make sure is that you completely understand what the title says that you can and cannot do. And that's where it's critical that you get the right team behind you to actually read it and tell you, okay, you're looking at a site, you're wanting to maybe convert it from, I don't know, there's a solo dwelling on a plot of land, and you know that in terms of the market, you can make more money if you knock it down and put 3 townhouses or put a semi-detached, or even you could try and split it up and get more. Now, you could get planning for that, and that's absolutely grand. But if you've got a restricted covenant on that title, which says the property or the plot only allows one private dwelling house, then immediately you're encountering a blockage because you would be in breach of that restricted covenant that's in place. Or there might be things whereby you've got the same plot of land, you're wanting to build multiple dwellings on it, you've got no restricted covenants in terms of the number that you could build, but it's a shared driveway with another plot of land, further on. And you've only got the benefit of a right of access along that plot of land. Now, you can't enlarge a right that you have. So you might be able to have a right of way for one car, for like one house to access it, but you don't have an enlarged right of way to allow access for 7 houses that you could build on the site. So it's things like that you're looking at it. So immediately we've got 2 potential issues that people need to be aware of: rights of access and rights of way, which kind of sit together. They're not exactly the same, but they're in that similar field. And then restricted covenants. Now, then a third immediate one that kind of sits nicely with that is rights to light. So you might have a plot and it might have, I don't know, a bungalow on it. And you think, well, I could actually put a block of flats on that, or I could put a bigger house on there. But actually, you might have to be alive to the fact of, well, what are the neighbouring properties doing? Where do they sit? Where's the viewpoint? So if I go from having like a 1-level property to 2 or a 3-level property, am I now going to be facing directly into the back of somebody else's property? Am I breaching their rights to light and privacy? So again, this is where you would need to get a specialist surveyor, like a rights to light surveyor, to come in and advise you. So that's your 3 things so far. A 4th thing that people need to be aware of is also party wall issues. So that becomes more pertinent if people are, for example, the properties are adjacent to each other and they're either going to dig down below into the basement. So that's particularly important in London, where spaces are premium and they go down or they go up because they can't go out. Or if you are, I don't know, again, as a small semi and you're wanting to enlarge it, you have to be alive to the Party Wall Act and think of all those issues. So that's where it's really critical to read the title, talk to your lawyers and your team of surveyors about what you're actually wanting to do, and then find out if you can do it. Because what you don't want to do is make a costly mistake of going gung-ho, putting your spade in the ground, and then finding you've got problems.
Brilliant. Can we go? I mean, that's a brilliant start, and it prompts a lot of questions because I think this restricted covenant one is quite interesting. And I've been in the industry many years, and normally you deal with these. I have one where I got caught out, and that was actually a property that I bought myself, and we had a long plot, long driveway, and I had a separate access up of a shared driveway that went to the fields at the back. And I used to go up there and drive in the top of my land to actually get to the sort of garden buildings where the lawnmowers and stuff were kept. And I was actually at one point, Simone, thinking about building a garage block up there because I'm a bit of a petrol head. As it happened, Mrs. C, carte blanche, she put a stop to that anyway. So that she didn't want to look out up the top of the garden, which looked over fields with horses, a garage block with cars in. So that it wasn't going to happen. But when I actually looked into it, my lawyer then went, hang on a minute, no, you've only got restricted access for garden use. Although you can take a car over it, you can't take a car over to park in a garage, you can take a car over for garden use. So it's very subtle. So I think that's a brilliant point. And I want to just home in on that a little bit further, because you're right, people could get planning permission, but the planning permission doesn't mean you can build it because you've got these restricted covenants. What do we then do if we've got a restricted covenant? Let's say, as you said, we've only got rights of access for one dwelling, and we might want to have several dwellings. Or if we've only got access, and this is one I've seen before, for commercial use, if we've got a commercial building and we want to convert it into residential, which we can do under permitted development rights, we can go ahead and do that. We've got the planning permission, but we haven't necessarily got the permission to put residential traffic through it. How do we get over these restricted covenants?
It's very tricky. So in terms of the path of least resistance, it's always to try and negotiate and see if you can reach a commercial agreement with whoever's got the benefit of the right of way. So they've got the retained land, and then you've got the right on top of it. So if you know who they are and that you can get in contact with them, people may agree to extending the scope and nature of the right. And that's your easiest way, because then you can document that in the title or, an addendum document. If you can't get that agreement, you're under serious problems, because what you have to show, again, without going down into the mechanics, if you've got an express right, it's obviously reserved in your title and you can see it. If you've got an implied right of way, then it becomes more difficult, because there's nothing in writing that people can rely upon. And you might be relying upon the predecessor in title's use of the land, and then so they've required a prescriptive right. I suppose the starting point is you can't, by its nature, without both parties agreeing, you can't extend the scope. So at first blush, I would say you're on a bit of a hiding to nothing if you're trying to enlarge it without the agreement of the other side, because you can't, by its nature, do that. So it's very difficult sometimes.
Simone, that's great. What about if we are buying a property? Okay. This one popped into my mind actually, literally just a week or so ago. One of the students came up to me and I said, you need to go back to your lawyers to ask on this one. You definitely need to get this clarified. This particular building, so he was buying the building, an existing commercial building, which he has permitted development rights under planning to convert to residential. But his solicitor had uncovered a restricted covenant on his land, wasn't nothing to do with access, that the building could never be altered. Okay, the building had to remain as it was, so presumably in commercial use, couldn't be physically altered under this restricted covenant. And so his solicitor said, well, you're a bit of a concern here. And of course, the benefit of that restricted covenant is no longer around, and it's very difficult to find out who they are. What happens in those situations?
So restricted covenants are slightly different, because you have got a statutory mechanism in place that you can apply to the tribunal to get it modified or discharged. So let's work on the basis that you do know who's got the benefit of the restricted covenant. Again, I would always say, if you do know who it is and you can establish who they are, particularly in some areas where you had families that had a lot of estate, and then they've sold it off over the years. That one family, so down in Bournemouth here, there's about 3 or 4 families that had large swathes of Bournemouth and Poole, and so they've retained a lot of restrictive covenants in the benefit. So you know who they are, so you can approach them directly to see if you can negotiate an exchange or an extinguishment, I should say, or a modification, or a complete release. If you don't know who they are, then you can apply to the tribunal, and there's a whole statutory framework in place that allows you to do that, where you can say either the benefit should be extinguished, or there might have been, for example, in your one, that it was commercial use. Let's just change the word, change the scenario, and it had got converted slightly, and then you were then seeking to do an additional conversion, and then you found out about the issue to do with the restrictive covenant. At that point, you could then, for example, say to the tribunal, well, hang a minute, it's not pure, there's been a dilution in the past, and therefore it would be reasonable for a further dilution, because that initial dilution took place, nothing's happened as a result, and therefore, please, can I carry on? The tribunal might take the view, yes, look, it's happened in the past, so actually a wee bit of an extension of that dilution is okay. Whereas if it had been just commercial and then you'd gone straight for it, the tribunal might turn around and say, no, that's too much of a change, or it's not in keeping with the area, it doesn't fit with public policy. So they will look at things in the round as to the strict wording of the covenant, to see whether it can be extinguished or modified. There's been lots of different cases, but it literally turns on the individual wording of each restricted covenant and the individual facts in the case. So you will always be able to get general advice, and people, like litigators, will be able to say to you, okay, so this is what the framework says. These are your facts. These are similar case law that kind of sits within yours. And on that basis, I would say the prospects of it and the merits of the claim would be X, Y, Z. You know, us litigators shy away, or any lawyer ever, from giving a guarantee, because we can't. And what we can do is like what I call a sliding scale of risk. And you've also got the benefit, you can get insurance as well, like indemnity insurance to protect.
I was going to ask that. So we can get insurance because if this person is deceased, no longer around, obviously the benefit of that restriction there, that restricted covenant, is unlikely to ever be exercised. So I presume, along with your advice on a risk rating, one can potentially find insurance against that.
Absolutely. And again, the premium, so I suppose 2 points. One, would you be covered? And two, if you were, what the premium would be. That will depend, again, on the wording of the restricted covenant and the specific facts. But the way in which I approach litigation is there is always a way to resolve it. We've just got to think outside the box or think in a slightly different way, but we can always get over a hurdle. And if it's not 100% resolved, then it's about at what point in the sliding scale somebody is comfortable with the risk. So if I can say to you, I can eliminate 80% of the risk, and you've got the 20%, and that 20% you can buy it off by way of an indemnity policy, then the client goes, right, okay, I've made an informed decision and I can take it forward. That's my job as a litigator, is to give clients and developers the ability to make an informed decision, balance on the risks and the probability, to say, I'm comfortable with this or I'm not. And developers are, some of them are really risk averse, and some of them are very kind of commercially minded and quite happy with risk. And it's just about having those really open, honest, transparent, pragmatic commercial conversations. And I'm saying to the client, where are we sitting on the scale of risk? What do I need to do mitigation? And then you tell me whether you're happy, and I can give you the proposals according to what you're most comfortable with.
Okay, and I think with that, we've also got to think about, if we're developing something to sell on, all those individual units, purchaser solicitors are going to be looking at this as well. So we need to get a position which is going to be comfortable for a purchaser solicitor, who are going to be very risk averse, I'm guessing.
Absolutely. And this is where, when you're a developer, you've got kind of several hats on. So you're thinking about, I'm viewing the site. Is the site as a continent, conceptually going to work with what I want to do? A. B, is what I'm seeking to build on it profitable? Because what's the point in building something or developing something if you're not going to make any money? And C, how easy is it to flip on? Because if I've got lots of problems, so I had a client, for example, that had bought a old coal mining pit, and it was like where the old slag heaps and things were that were kind of next to it, and they were all redeveloping it. But the remediation costs to do that was astronomical. But they knew that they could get a large, shall we say, worldwide packaging and delivery service company that sounds the same as a jungle somewhere in the rainforest, and there's a river that runs through it, that they could get them as a large warehouse. So the costs and the cost of the remediation were lower than the benefits that they could get of getting them as a tenant. So therefore they knew that it was worth it, but they had to include that in the calculations. They had to work out exactly what those unforeseen remediation costs were going to be. They then had to get like indemnity insurance because there was restrictive covenants in place, and they also needed the security of knowing that they could get the potential tenant like on the hook as a tenant, because then they could factor that into what the cost would be. By taking all of that into account, they knew it was worthwhile to develop. So it's short, medium, and long-term planning with different hats on. So you got your development hat, your build hat, your profit hat, and then your long-term flip hat, if that makes sense.
Yeah, it does. Let me move on, just expand this a bit in terms of, we're talking about, problems that people can come up with. What are the most common? Because I'm sure there are some, which obviously then leads to, as developers, the things we need to put right. What are the most common causes of any dispute or litigation that you come up with in property development? Can you give us maybe 2 or 3?
So, briefly touched on them before. It's always not reading the title properly, not understanding the restrictive covenants, rights of way, rights of light, and also the last one's just gone out of my head, Party Wall Act, always. Yeah. And for example, down here, we've got quite a lot of issues with TPOs, so tree preservation orders. Yeah. And people don't understand. So they might look at a site. So as an example, there's a site down in Sandbanks that people have been trying to buy for years. But the way in which it is located is there's quite a lot of trees and they've got TPOs in them. So people don't sometimes appreciate that it might be the tree. It's not just the tree. It's there's a whole kind of circle of exclusivity around it. So you can't build within because to do with the roots. So when you could look at a plot online and be like, oh, great, I'll just get rid of the trees and then I can build and then I can make loads of money because it's Sandbanks, great. But I'm like, yeah, but you can't get rid of the trees and you can't build within a 15-meter zone of each tree. So then you've gone from having this wonderful plot that you could develop out to actually, I'm just buying a plot with trees and I can't do anything with it. And it's having that
people
awareness.
Would be so interested in that in Sandbanks and home in on that because it's one of the most expensive bits of real estate around. Yet just a bit of land with trees in is not worth anything to anyone in a way. Exactly.
So there's I think it was last week a plot at Sandbanks sold, and it's the most expensive per square foot in the world to buy now, and it was 13 million for a bungalow. Now it's not the bungalow that's worth any money, it's the plot of land, because they can put the planning on it and it's got direct access to the water, it's got a mooring station. I don't really know the working, but you can moor up, go straight on it. The actual size of the plot is about 1.5 acres, which is massive for Sandbanks. And so that's like an incredible bit, because what normally happens in Sandbanks, just as an example, is that you'd have the plot of land and then it would have like a wee bungalow, but it would be a very tight plot, and then everybody kind of goes up, and because they can't go down because it's sand, and they can't go wide. The costs to develop, I have a lot of developer clients that develop in Sandbanks in the marina, and it's quite interesting because it has additional complications than if it was just somewhere with normal soil, because the costs that they have to do for the piling, because of the instability of the ground and all the sand, etc., that they have, is that that is a massively additional build cost that you've got to factor in, that if you were doing exact same development further up the road, you wouldn't even be thinking about it, because those costs are almost unique. And it's things like, because it's so exposed to the water and it's on both sides, you've got to use certain materials that are resistant to the salt water, for example, and the tides. There's a whole different factor. So that's Sandbanks, but the same principle applies. If you're looking to develop in an area that's a little bit more unique, maybe it's like in Norfolk with the Broads, or you've got the higher floodplains, things like that are just a bit different than normal. I was up in Tewkesbury, and obviously that's got a high risk of flooding. So you have to be clever and aware of, and have that in the back of your mind of, okay, they've got a high risk of flooding. Where is it that I'm thinking about buying? Where do I need to think about what type of development could I do there? Do I have to build it in a slightly different way so it's more kind of responsive and will be able to be better at dealing with or any flooding issues? It's things like that as developers are, what I would say, not a common thing in your textbook conveyancing land that you would think about, but it's being live to those unusual issues that wouldn't normally kind of come across your mainstream development build. But you can get higher rewards with them as long as you do it properly.
Simone, which I think is interesting, listening to this, anyone listening to this, one thing you should take out of this is we're listening to a lawyer, a property lawyer who knows quite a bit about property development. Okay. And it's interesting, a lot of the property lawyers that I know, rather than just a lawyer, okay, but a property lawyer, will often give you lots of advice because they've got lots of experience of working with lots of developers. And we hear Simone talking about piling and materials under salt conditions, and we're talking about flooding and the Broads and Tewkesbury. Lots of things here that if you are listening to this and you're new to development, look at the benefit of actually getting good property people, including your lawyer, around you. Let me go back, Simone. We talked about the team, getting the right team in place. Lawyers are part of our team. Can I ask you, in terms of when we talk about disputes, disputes and litigation, do you normally get hired once the dispute has occurred? Or is that the norm? And I'm guessing really what we should be saying is people should be thinking about getting you on board to avoid that dispute in the first place.
Yeah. So my existing clients, I have them well trained now, so that if they're thinking about buying something or doing something, I am always like, just run it past me first. It doesn't have to be like a real deep dive into anything, but I can look at a title and be like, oh, you need to check this out, and go and do some investigation and then come back to me. Or I might know that site because I might have dealt with it or a neighbouring, and I'm like, yeah, actually, these are things that you need to be live to. So in an ideal world, I'd love it if people brought me in a wee bit earlier to say, I'm thinking about doing something and what's the issue. More often than not, though, and I fully appreciate as a litigator, I'm what's viewed as a distress purchase. So they often reluctantly engage my services. And that's absolutely fine if you do it at that point. But because at that point, I'm on damage limitation and getting you out of the problem and fixing it. Like my job is a problem fixer. But I also want to be a problem preventer. And I would much rather be the preventer than the fixer. Because I have two different hats that I wear as a litigator. I have one that is to prevent the litigation going to issue or court proceedings being involved, and then the other one is we're at that point and then trying to get us out of it and by settling it. So in an ideal world, I'd love to be working with people earlier on, but I appreciate that people are scared to almost pick up the phone to me, because then by doing that, you're acknowledging that there may be a problem. And that is sometimes half the battle that I have is to say to people, right, we're in a situation here. Now we have to actually deal with this. Whereas if you'd come to me a couple of steps beforehand, the problem is 9 times out of 10 never as big as if you've waited and then come to me once it's already arisen.
And I'm guessing here, I mean, you're head of property at Woodstock. It's coming to you at the beginning, having a firm of lawyers that has all of the requirements there in terms of legal services, and actually coming to someone like yourself, Simone, and at the beginning, and then that's identifying those problems and flushing those out before we get anywhere. So it's actually using the right firm with the right expertise, I guess, right at the start is important.
Yeah, and so we are very much focused on working as a team and tag teaming. So I work closely, for example, with my colleague, Roger Clayson. So he does commercial property and development. He and I will look at things together, and we're always bouncing ideas off. So I'll be like, he'll say, well, I've got a client who's wanting to buy this, but there's this restricted covenant on title. What do you think? And I'll be saying, okay, well, these are the options and this is what we could do. What do they think? Let's just have a call, the three of us, and bash it out between us as to getting that strategy. I think sometimes what I call non-contentious lawyers are a little bit reluctant to get the litigation contentious lawyers involved straight away, because then they think, oh gosh, there's a problem. And I'm like, no, it's just that we look at things slightly differently, and then we can, in my mind, give the client the best opinion, because they're getting the best of both by us looking at how they fix it, and then also, for example, with Roger, drafting the documentation in the best possible way. And sometimes if he's drafting it with me in the background saying, these are the things that we need to think about, so can we kind of box that off in the drafting, and then he'll do that product so that the client's risks are, as minimized as possible, then to me, that's the best way for a client, because they've got the benefit of, how do we fix it? And here's the documentation to fix it. To me, that's a no-brainer. But I must say, it's not just about the lawyers as well. It's getting the right surveyors in too. So surveyors are like, I think of it like a little tripod. They're really, really critical too. So if you've got Party Wall Act issues, you need a Party Wall surveyor, not just a building surveyor, a Party Wall specialist surveyor. If you've got rights to light issues, you need a rights to light surveyor. If you've got, I don't know, enfranchisement, or you're wanting to do extended leases, or you're going to sell the freehold, you need evaluation surveyors that are specialists in that. Pick your best players for your team. It will save you so much more time and money in the long run.
Good stuff. You mentioned Roger Clayson's going to come on the show in a few weeks' time, folks, so listen out, look out for that one. We'll have Roger on at some point. Can I just finish off today, Simone? I'm conscious of time. I want to let you get away for the rest of your day, but there's been a lot of talk, a lot of news out there in terms of freeholds, okay? And the value of freeholds. We used to be able to sell the freehold off afterwards for a multiplier. We're now into these sort of peppercorn rents. What is the latest? What can or can't we do on freeholds if we are taking an existing commercial building, turning it into a block of flats? We want to sell the flats off leasehold. We're left with the freehold. What can we or can't we do? What can we charge? What's the latest?
I find this one quite tricky, because I deal in facts, not in sound bites. And at the moment, there's a lot of sound bites and a lot of press releases on Michael Gove last week. That's great, but give me something concrete to work on, and then I can advise people properly. So I think what I'd be saying to people is, there is one bit of certainty, which is obviously the Leasehold Ground Rent Reform Act, and that's basically said that from the 30th of June 2022, you can't charge ground rents on new long leasehold interests. Existing ones, it's not retrospective, so they stay as they are. So anything new, you won't get the benefit of that ground rent. What impact is that having short term? Very little. That's medium and longer term, because with every new build that's going on, the stock, I suppose, or the values of the ground rent will slowly but surely diminish, because the peppercorn, it'll become peppercorn rather than having a value. The addition to that, I suppose, is every time you do a lease extension, and this isn't anything new. This is what's been going on since the 1993 Act, that obviously when you extend a lease, yes, the landlord gets the benefit of the premium for the lease extension, but the ground rent drops to a peppercorn. But that's why you get the premium, to reflect the fact you're no longer getting the ground rent. That's not changed, and they've spoken about changing it for 3 years now, and it's still not happened. But in theory, the proposals are that the lease extensions will go to 990 or 999 years, and it goes down to peppercorn. So I suppose what you could be saying is, if that did happen, then the value of the freehold will lose that layer of value if the statutory lease extension process goes in that way. However, my caveat to that is, there's nothing in legislation that's saying that that's going to happen, and it is a soundbite. So any of these changes are going to be medium to longer term, if and when they come in. Short term, no real changes. And most importantly, there's nothing in the legislative timetable to show that these are actually taking place. Great
stuff. Simone, I think that's great. I mean, hopefully out there, everyone listening to this today has got a whole load of great facts. I'm sure we could talk for hours, and maybe we'll get you back again at some point in the future. If people want to reach out to you, what's the best contact details?
Best one is, you can either phone direct at Woodstock, or you can send me an email. So that's s.ritchie with a T at woodstocklegalservices.co.uk, or I'm on LinkedIn, or go to the Woodstock Legal Services website and you'll find my face there, and just click on it.
Great stuff. What we'll do is we'll put all your contact details in the show notes, so let anyone pick these up, they'll be there below. And do you work nationally across the country? I know you're based down on the south coast in the lovely sort of Poole area of Dorset.
Yeah, so I used to practice in Manchester. So I have a lot of developers and contacts still from the Northwest and London. I myself work internationally and nationally, and most of the team are national as well. So yeah, we're right, broad gamut. The only thing that we don't do is Scottish property, because it's Scottish law. But I have contacts that I then refer people to that I used to know when I was practicing. But I I don't do Scottish law anymore, but that's the only one. It's just the Scots were awkward. Sorry.
I'm no comment necessary, I don't think. Simone, that's great. Look, thank you for coming in. I do appreciate it. And we look forward to seeing you again soon. We'll get you back in the future at some point.
Thank you.
Thank you. Wow. How good was that? I mean, what a huge amount of information, literally in about half an hour. Okay. I'm sure we could have talked for ages, but we'll get Simone back in the future. If anyone is interested in property development, if you're out there and you're dipping your toe in the water for the first time, grab a pen and paper. I'm going to give you a link for a bit of free training, might just help you out. So just write this down, propertyceo.co.uk/SFR, propertyceo.co.uk/SFR, which stands for six-figure roadmap. And then you can pop onto there and it gives you a bit of free training. And of course, please reach out to Woodstock. I'm going to put their details in the chat box. And please connect up with them. I'm sure you want to get these people on board before it's too late. Great stuff. Look forward to seeing you all soon. Cheers now. Bye-bye.